Hi, I'm Thomas McFarlane and I'm a Senior Associate in the Dispute Resolution and Litigation team here at Shepherd of Wedderburn. In this video, we're going to explore the use of the phrase without prejudice. Solicitors commonly use the phrase without prejudice in their correspondence, either on its own or as part of a variety of different types of elaborate paragraphs. But what is this wording seeking to achieve? Put simply, it is intended to make the correspondence inadmissible in court. This is normally to prevent offers that have been made during the course of negotiations later being referred to in court. It is therefore used to encourage parties to resolve matters out of court and to prevent statements made in a genuine attempt to settle being used against them. However, including the wording is not a magic spell. It doesn't provide unfettered protection, and it does not automatically mean that the opposing party will not be able to refer to and rely on the relevant correspondence in court. The content of the correspondence needs to be considered, and there is a distinction between 1. Statements made in an attempt to settle, and 2. Admissions of fact within privileged communications. Without prejudice protection covers correspondence, concessions or statements made with a view to trying to achieve a settlement, but that does not prevent that same correspondence being referred to either where there is a clear admission or statement of fact or in relation to expenses. The potential protection is therefore fairly limited, and care needs to be taken in relation to any statements or admissions made in any correspondence, regardless of whether or not without prejudice wording is included. If a statement of fact is not later to be used against a party, it must be clear that it is a proposition made for the sake of settlement and not an unequivocal admission of fact. What is important is the correspondence itself, not the without prejudice wording. Correspondence which is not genuinely aimed at settlement could be admissible in court. Indeed, the correspondence itself may be put before the court in order for its admissibility to be considered in the first place. We hope you found this video on without prejudice communications of interest. If you have a dispute on which you require legal advice, please do get in touch.